Okay, good afternoon, everyone. Welcome to our first family webinar of the 2022-2023 school year. My name is Sarah Untersea. I'm a consultant here at Region 10. We also have Jim Wright with us today from Partners Resource Network, and we are so happy to have you here for the Know Your Rights webinar. We're going to go ahead and get started. We are recording today's webinar, and it will be available on the Region 10 website for you to go back and watch later if that's something that you would like to do, if you'd like to share that with someone that wasn't able to be here today. So as a parent of a student with a disability, it's important to understand your rights and your responsibilities. And although all parents are receiving that copy of those procedural safeguards, we know that very few are actually taking the time to read it. And so during today's webinar, we're going to go through the Notice of Procedural Safeguards that explains the parents' rights and responsibilities under the Individuals with Disabilities Education Act, or IDEA. The presentation today is going to provide a brief overview of each section of the procedural safeguards. And we encourage all parents to read the full version of the document, and it is available under Parent Resources on www.spedtext.org, which has all kinds of fantastic resources for parents in addition to those procedural safeguards. When should I receive a copy of procedural safeguards? IDEA requires that school districts and charter schools provide the procedural safeguards to parents at least once a year, as well as on the following occasions: upon initial referral or your request for evaluation, the first occurrence of filing of a due process hearing, complaint, or special education complaint during a school year, anytime there's a disciplinary change of placement, and then also anytime there is a parent request for those documents. Language requirement. Schools are required to provide a copy in the parent's native language or other mode of communication unless it's clearly not feasible to do so. SpedText has translated the procedural safeguards and ARD guide into 24 languages, with more on their way. So we are constantly working to update that and get that in as many languages as we can. And again, both documents are available for download under the Parent Resources section at spedtext.org. So our safeguards start out with foster parents, and that is on page 1 of the safeguards. A foster parent for a child with a disability may serve as the parent if they agree to participate in making those special education decisions and complete the required training before the child's next ARD meeting, but not later than 90 days after they begin acting as the parent. There is also some information on surrogate parents. If after reasonable efforts, the school's not able to identify the parent of the child, or if the foster parent is unwilling or unable to serve as the parent, or the child does not reside in a foster home setting, or the child is a ward of the state or an unaccompanied homeless youth, the school must appoint a surrogate parent to act in place of the child's parent. Oops, sorry guys, let me go back. The school must appoint a surrogate parent to act in place of the child's parent unless the child is a ward of the court. Surrogate parents must complete the training program before the child's next ARD meeting, but not later than 90 days after the initial appointment as a surrogate parent. So that's similar to for our foster parents. On page 2, we move on to Child Find. Child Find tells us that all children with disabilities living in the state who need special education services must be identified, located, evaluated. This includes children with disabilities that attend private schools and also those that are being homeschooled. Prior written notice, which is also on page 2 of those safeguards. The public school must provide you with written information that's called a prior written notice. It must provide that before it proposes or refuses to start or change the identification, evaluation, educational placement, or special education services provided to your child. The school must provide you with the prior written notice, even if you agreed to the change or requested the change. And schools must give you prior written notice at least 5 school days before it proposes or refuses the action unless you agree to a shorter time frame. Parental consent. Informed consent means that you've been given all of the information related to what the school is asking permission to do. Consent is voluntary, so granting of your consent is voluntary and it can be revoked at any time, but you must do so in writing, and revoking consent is not retroactive. So anything that had been done up until that point of revocation cannot be undone. Parental consent is required before conducting an initial evaluation for special education. To provide special education services for your child for the first time, and to reevaluate your child unless the school can demonstrate that it took reasonable measures to obtain your consent and you failed to respond. Independent education evaluation. If you disagree with an evaluation provided by your child's school, you have the right to request that your child be evaluated at the school district's expense by someone who does not work for the school. This is called an independent education evaluation, or an IEE. When you ask for an IEE, the school must give you information about its evaluation criteria and also where to get an IEE. The next section of the safeguards deals with student discipline. So if your child violates the school's code of conduct, the school must follow certain procedures if it removes your child from their current placement and if that removal constitutes a change of placement. So for up to 10 school days, your child can be suspended for that amount of time during the school year without it creating a change of placement. If your child has been suspended for more than 10 days, then a change of placement has occurred, and an admission review or dismissal, ARD meeting, must be held in order to conduct what's called a manifestation determination review, or an MDR. That manifestation determination ARD committee will review all the relevant information and will determine if that misconduct is a manifestation or caused by the child's disability. And if it is the result of the school not implementing the student's individualized education plan, or IEP. Is the misconduct a manifestation of the child's disability? If that answer is yes, and if there is not a behavior intervention plan, or BIP, the school will want to conduct a functional behavior assessment, or FBA, and possibly implement a BIP. If there's already a BIP, the school will review and modify that BIP. If the misconduct is not a manifestation of the child's disability, then your child can be disciplined in the same manner and for the same duration as non-disabled children. However, your child must continue to receive that free, appropriate public education, or FAPE. Discipline procedures are on page 6. If your child's conduct was the direct result of the school's failure to implement your child's IEP, the school must take immediate steps to remedy those deficiencies. Your child must be returned to the placement from which they were removed unless the misconduct involves a weapon, illegal drugs, or serious bodily injury to another person. There are protections for your child if they have not yet been determined eligible for special education, if the school had knowledge that your child has a disability before the behavior that resulted in disciplinary action. The next section is about education records. Upon your request to review your child's records, the school must make them available to you without unnecessary delay and before any ARD meeting, due process hearing, or resolution session, and no later than 45 calendar days after the date of your request. Is there a fee? If you request copies of your child's records, the school may charge you a fee for copying as long as that fee does not keep you from being able to inspect and review those records. Consent. Your consent, or the consent of the adult child, must be obtained before education records can be released to people outside of the school. So anybody in an outside organization, anybody that's outside of the Texas public school system. Private school placement by parents. Parents do have the right to voluntarily place their child in a private school, but federal regulations do not require a public school to pay for the cost of education, including special education and related services, for your child with a disability that's at a private school or a facility if the public school made that free appropriate public education available to your child. Okay, the next section is about transfer of parental rights. This is on page 11 of the safeguards. All parental rights under federal regulations transfer to your child when the child reaches the age of 18 in Texas. At the age of 18, your child has the right to make their own educational decisions. The school must still provide you with notices of ARD committee meetings and prior written notices, but you may not attend that ARD meeting unless the adult child specifically invites you to the meeting or the adult child gives you that right in a supported decision-making agreement. On or before the student's 17th birthday, the school must provide you with written notice about that transfer of parental rights to your adult child unless you obtain guardianship or if the student signs a valid power of attorney or a supported decision-making agreement. Your child's school will be communicating with you regarding that transition process, but it's really important to begin considering those options for your family as your child starts to get up into that age range. Okay, beginning on page 12, we start talking about resolving disagreements. Texas Education Agency, or TEA, has options for resolving special education disagreements, and these are covered on pages 12 through 14. The first is state IEP facilitation. The disagreement must relate to an ARD committee meeting where mutual agreement was not reached on at least one of the required areas of the IEP, and the ARD committee agreed to recess and reconvene. Mediation services. The goal of mediation is to assist the parent and the school in reaching agreement. Special education complaint resolution. Written complaint must describe the special education violation, facts on which the complaint is based, the parent's signature, and the contact information. And then finally, due process hearing program. A parent can request a due process hearing from TEA on any matter relating to the identification, evaluation, or educational placement of their child or the provision of FAPE to their child. So you can see that there are lots of steps outlined there to help along the way. The other thing that I would encourage parents to do is look at the very end of your procedural safeguards. You're going to see some numbers listed there and some contact information for area agencies and resources. And those people can really be of assistance if you find yourself in a situation where you do have a disagreement with your child's school. It's always important to remember that parents and school are on the same team. Everybody is trying to work for what's best for the student. And so the state has provided a lot of options for the two parties to try to come together and reach that agreement. Okay, that is the end of the presentation. We do have the SPED text information there again for you. We have a QR code that links to SPED text, as well as the phone number and the website. SpedText, if you haven't heard of it or if you haven't used it before, is a phenomenal resource. The website is phenomenal. We also have folks available via phone, via email, via chat that can answer questions for parents across the state for any special education related question. Okay, Jim and Katrina, do we have any questions in the chat? I know we have a few minutes, so if we wanted to take a few questions, we probably could do that.
I don't see any in the chat.
I must have been talking fast because we finished earlier than I thought we were going to.
No, you did good.
The flow was very good.
Jim, is there anything you wanted to share as a parent about the procedural safeguards?
I just want to say, and I can't get my video to come on for some reason, but I just wanted to say that if you have not read your procedural safeguards, that's okay. They're there for when you need them. You don't necessarily have to become an expert before you need them. But if you have any point in your in raising your child and working with your child, and there's questions that you may have, or you're not sure about something, this is definitely the resource that you want to go to. That it's mandated by the federal government, that all states have that, and that it's, it's pretty uniform, and it's really designed to foster conversation and communication. Because as long as we're communicating with each other, as long as the team and the parents have the interest of the child, eventually we'll get there. We may sometimes have differences of opinions on how to get there, but we can only figure out how to get there through good communication. And so it's important to know that, that's how the law is designed, that's how the systems are designed, and it's how the education system is trained to do that. So just know that this resource is there for you to provide that guide map in case you find a situation where you're a little bit frustrated or not unsure of yourself.
Absolutely. And if anyone does think of questions after we finish today, I did include my email as well as Jim's email here on this last slide. And we are happy to answer questions for you as well, or direct you to the right resource. Okay, if we don't have any questions in the chat, then I think that we can wrap up for this afternoon.